My name is Mary McDowell. This proceeding will come to order. I am the Chief Deputy Treasurer, and I have been designated by the Governor to preside over this hearing today. The hearing has been requested by the officials of the City of Detroit pursuant to Section 15 of Public Act 72 of 1990, the Local Government Fiscal Responsibility Act. On December 18th, the Governor appointed a financial review team to examine in detail the financial condition of the City of Detroit. The review team reported its findings to the Governor on February the 19th, 2013. Based upon those findings, the Governor determined that a financial emergency existed within the city. By letter dated March 1st, 2013, the Governor informed the Mayor and Council of the City of Detroit of his determination. As required by Act 72, the Governor's letter also included findings of fact utilized as the basis upon which his determination was made, a concise and explicit statement of the underlying facts supporting the factual findings, and notice to the City of Detroit officials of the opportunity to request a hearing conducted by the Governor or the Governor's designee. The purpose of this morning's hearing is to afford city officials an opportunity to indicate whether the findings contained in the review team report were supported by competent, material, and substantial evidence on the whole record. So let me offer you a reminder of the basic ground rules for this hearing. First, the Michigan Court of Appeals noted in 2002, while Act 72 provides for a hearing, it does not specify the type of hearing that is required. The court concluded that the legislature left the scope of the hearing and other procedural matters to be determined by the Governor at his or her discretion. Second, the court also noted that the statute does not encompass any right to present evidence of actions taken by city officials since the review team filed its report, or that concerns actions city officials anticipate taking in the future to address the financial emergency of the city. Such evidence will be considered beyond the scope of this hearing. In other words, this is not an original fact-finding hearing. The purpose of this hearing, as I mentioned a moment ago, is to afford city officials with the opportunity to indicate whether the findings of the review team report were supported by competent material and substantial evidence on the whole. Third, the hearing is not an adversarial hearing, nor is it a contested case hearing pursuant to the Administrative Procedures Act. Formal rules of evidence will not apply, and there will be no cross-examination of either side by the other side. Fourth, each side, that is the review team and the city, will have a total of 30 minutes to make a presentation. This will consist of 20 minutes for an initial presentation and 10 minutes additional for rebuttal. More than one person may present. However, the total time allotted per side will remain at a maximum of 30 minutes. Finally, I will accept any additional written comments from either side until 5 p.m. today. I may have questions as we proceed. If so, I will ask them at the time. To facilitate my review of today's proceedings, a court reporter is present to produce a verbatim report. With that, I think we can begin. We will first have the presentation of the review team findings. That presentation will be made by Fred Hedden on behalf of the financial review team. Mr. Hedden?
Thank you. For the record, my name is Frederick Hedden. I am the State Treasurer's legal advisor and a member of the Detroit Financial Review Team appointed by the Governor. The matter before you this morning began on December 10, 2012. On that date, the State Treasurer by letter informed the Mayor of Detroit and the President of Detroit City Council that the Department of Treasury would conduct a preliminary review of the city's finances pursuant to Public Act 72 of 1990, the Local Government Fiscal Responsibility Act. On December 14, 2012, the State Treasurer reported to the Governor the results of the preliminary review. That review concluded that a serious financial problem existed in the city of Detroit. In response to that review, the Governor appointed a 6-member review team on December 18, 2012. Act 72 of 1990 requires that a review team transmit to the governor a report containing one of the following three conclusions. A, that a serious financial problem does not exist in the local government. Or B, that a serious financial problem does exist, but that a consent agreement containing a plan to resolve the problem has been adopted. Or C, that a financial emergency exists because no satisfactory plan exists to resolve a serious financial problem. On February 19th, the review team reported to the governor its conclusion that, in the words of the statute I've just cited, a financial emergency existed in the city of Detroit because no satisfactory plan existed to resolve a serious financial problem. On March 1st, the governor determined, pursuant to Act 72, that a financial emergency existed within the city of Detroit, and so informed Detroit officials in writing. On March 7th, the Detroit City Council requested today's hearing to appeal the governor's determination. Because the governor's determination was based upon the review team report, I would like briefly to explain how the review team arrived at its conclusion. The Detroit review team met on December 19th and 20th, 2012, and on January 3rd, 7th, 9th, 16th, 25th, and February 1st, 14th, and 15th. During these meetings, the review team carefully examined considerable information relevant to the financial condition of the city of Detroit. For example, on December 20th, 2012, a mere 2 days after we were appointed, we met with the mayor, the deputy mayor, 3 members of the city council, and 5 members of the city council's fiscal division, the city's chief financial officer, the finance director and treasurer, the program management director, the acting police chief, and 4 members of his senior staff, the fire commissioner and deputy fire commissioner, the human resources director, and the labor relations director. The review team would meet with many of these city officials on a recurring basis over the next 60 days. In addition to meeting with city officials, review team members also met with nearly a dozen union officials representing the Detroit Police Officers Association, the Detroit Police Command Officers Association, the Detroit Police Lieutenants and Sergeants, and the Detroit Firefighters Association. Everyone with whom we met, city officials and union officials, were cooperative and provided much useful information. Based upon a review of all the information gathered from these meetings and interviews, the review team found or confirmed the following. First, the city continued to experience a significant depletion of its cash. Projections by city officials had estimated a cumulative cash deficit in excess of $100 million by June 30, 2013, absent the implementation of what city officials referred to as financial countermeasures. The review team noted in its report that the mayor and city council deserved credit for considering, and in some instances adopting, difficult financial reforms in an effort to address the cash crisis. However, the review team found that those reforms were too heavily weighted toward one-time savings and applied only to non-union employees who represented only a small portion of the city's overall wage and benefit burden. Second, the city's general fund had not experienced a positive year-end fund balance since fiscal year 2004. Since that time, the general fund had cumulative deficits ranging from $155 million in fiscal year 2005 to $332 million in fiscal year 2009. The general fund deficit was $327 million in fiscal year 2012, which ended last June 30th. The primary method by which city officials sought to address these deficits was by issuing long-term debt. In fact, had city officials not issued debt, the city's accumulated general fund deficit at the end of fiscal year 2012 would have been far worse. Not $327 million, but $938 million. Third, as of June 30, 2012, the city's long-term liabilities, including unfunded actuarial accrued pension liabilities and other post-employment benefits, exceeded $14 billion. City officials had projected that over the next 5 years, the expenditures needed to fund only a portion of these liabilities would total approximately $1.9 billion. However, city officials had not, as of the time the review team filed its report, devised a satisfactory plan to address the long-term liability issue. Fourth, the review team concluded that the city charter contained numerous restrictions and structural detail which made it extremely difficult for city officials to restructure the city's operations in any meaningful and timely manner. These restrictions included numerous steps and time periods that had to be observed before certain proposed changes might be implemented, and provisions which made it all but impossible to restructure municipal services. Finally, the December 28, 2012 management letter, which accompanied the city's fiscal year 2012 financial audit, identified numerous material weaknesses and significant deficiencies in the city's financial and accounting operations. I noted earlier that Act 72 required the review team to reach one of three conclusions in our report to the governor: no serious financial problem, or a serious financial problem addressed by a consent agreement, or a financial emergency. I do not anticipate that city officials will this morning assert there is no serious financial problem in the city of Detroit. Based upon the information contained in the review team report, which I have summarized this morning, the evidence upon that point seems beyond reasonable dispute. So what then of a consent agreement? The review team concluded that adopting another consent agreement to resolve the city's serious financial problem was not an option. I say another consent agreement because Detroit officials entered into a first consent agreement, the Financial Stability Agreement, on April 4th of 2012. The Stability Agreement established a detailed framework within which city officials were to restructure the city's financial and operational activities. In their written submission for this morning's hearing, city officials devoted a number of pages to the Stability Agreement. It is noteworthy that they refer on several occasions to the Stability Agreement as the state's plan, as if city officials neither signed the agreement nor had any role in shaping its terms. Nevertheless, it now appears city officials believe the Stability Agreement is a cornerstone of their plan. But it was not always so. Barely had the ink dried upon the Stability Agreement before city officials challenged in court the validity of the agreement. And once those legal challenges were found to be without merit, city officials exhibited a notable lack of enthusiasm for implementing the terms of the Stability Agreement into which they had entered. Indeed, as we noted in our supplemental review team report, the initial work upon a number of the financial and operational reforms outlined in the agreement did not even begin until the fall of 2012, some 5 months after the Stability Agreement was executed. Therefore, the review team had little confidence that Detroit officials could or would abide by the terms of a second consent agreement when they had not abided by the terms of the first one. So contrary to what city officials have asserted in their written submission, the governor and the review team did not condemn the Stability Agreement. The review team did not take issue with the Stability Agreement. We took issue with the unwillingness of city officials to abide by its terms. In our review team report, we acknowledge that since the review team was appointed, city officials had advanced various proposals intended to address the city's serious financial problem. However, in arriving at our conclusion that a financial emergency existed within the city of Detroit, the most important consideration for the review team was not whether city officials had advanced proposals, nor whether those proposals, when taken as a whole, might constitute a plan. The only consideration was whether city officials had offered a satisfactory plan as required by Act 72. And after careful consideration, the review team concluded that city officials had not done so. That left only one statutory conclusion for the review team to reach: that a financial emergency existed in the city of Detroit. This morning, city officials may assert that they should be entrusted to resolve the city's financial emergency. They may assert that they have a plan to do so. They may emphasize actions they have undertaken since the review team submitted its report to the governor, and they may even emphasize actions they intend to take in the future, if only they might be afforded more time to do so. However, any recent or future efforts that may be asserted this morning by Detroit officials to address the city's financial emergency are not legally relevant. They are not the issue. The only issue is whether the findings in the review team's report were supported by competent material and substantial evidence on the whole record. The review team believes the answer to that question to be yes. That completes my testimony until rebuttal. Thank you.
You have indicated that you gave careful consideration to whether or not the city officials had a satisfactory plan as required under Act 72.
Yes.
What were the elements that you considered? A cash plan?
We considered an entire range, including the three items that are contained in the city submittal. One would be the stability agreement itself. Second would be the so-called milestone agreement, which was executed in November of last year. And the third would be the so-called cash crisis countermeasures that were undertaken in late December, early January. In addition to that, we looked at sort of evolving proposals for dealing with the city's long-term liabilities that one of the consultants had been working on, and any other information that city officials had provided to us. So we looked at a full panoply, if you will, of information in arriving at our decision.
And when you say evolving proposals, by January or February, there really was nothing that appeared to be a concrete. Was there a concrete proposal for resolution of the long-term debt?
No, there was not. There were efforts to develop either a 5-year or a 10-year plan that were evolving. I think at one point one of the review team members may have referred to this effort as a plan to develop a plan, but there was nothing specific or concrete to address the long-term liability issue, at least as of the time that we completed our work and filed our report.
Thank you, Mr. Hedden. Mr. Corley, will you be presenting the remarks today?
Yes, ma'am.
I will be the initial speaker, Deputy Chair, or Deputy Treasurer McDowell.
Would you please identify yourself?
Sure. My name is Edward V. Keelan. I'm the Acting Corporation Counsel for the City of Detroit. I'm representing the City Council here this morning pursuant to MCL 141.1215, Section 15 parent 2, post parent, which is consistent with the governor's March 1st proclamation that a local government financial emergency exists with the city of Detroit because no satisfactory plan exists to resolve a serious financial problem. While the city welcomes this opportunity to present its side of the argument, and we have already provided this tribunal with multiple exhibits in a binder and similar documents. Mr. Corley is going to make a presentation in a few minutes. Mr. Whitaker to my left may also speak, and Mr. Corley will, I think, has already submitted an additional voluminous report on his presentation. We would note for the record that this proceeding is taking place under Act 72, which, to my way of thinking, still has some legal infirmities that may yet be explored by higher courts in this state. It is the contention of the city that not only does a plan exist, but it is a plan that was promoted by the state in April of 2012 pursuant to the preceding Financial Stability Act, Public Act 4, and it has been administered by the hand-picked Program Management Director, Chief Financial Officer, and Financial Advisory Board from April of 2012 to December of 2012, and largely financed at great expense by the employees, taxpayers, and residents of the city of Detroit, the unit that the state now claims is in distress. Fundamentally, the basic defects in the city's financial picture have been known for several years and were in fact the basis that the Financial Stability Agreement was entered into in April of 2012, including a detailed and specific reform agenda. Since that time, a multitude of life-changing changes have been imposed upon the city employees: 70/30 health care, cost-sharing, unilateral changes in retirement benefits and retirement funding, wage cuts, and furlough days. Moreover, the city has contracted with or committed to over $50 million in contracts with outside consultants at the direction of the Program Management Director, who was retained in furtherance of the state-mandated reform agenda, the very plan that the governor now finds to be unsatisfactory. Significantly, the FSA has always provided a mechanism whereby the Financial Stability Board could declare a default after any material breach in the city's performance under the FSA, and yet no such default has been declared. Nevertheless, the governor declares no satisfactory plan exists. Mr. Corley is prepared to discuss the financial underpinnings of the plan and the cash conservation program, and I would ask him to address that aspect of the City of Detroit's presentation.
Good morning.
Good morning, Mr. Corley.
Good morning, Ms. McDowell. My name is Irv Corley. I'm the City Council Fiscal Analyst for the last 20 years. The City Council agrees that Governor Snyder has declared a financial emergency for the city, and we agree with that. However, we also feel there is a satisfactory plan to address the city's emergency. The existing plan contains three components: the consent agreement, which was crafted with the administration and the state, and that consent agreement contains 25 initiatives, which include initiatives regarding public safety, recreation, real estate, financial stability, and efficiency initiatives. 20 of the 25 initiatives are in progress. Other accomplishments under consent agreement is noteworthy: the creation of the Financial Advisory Board, the FAB, the creation of the Program Manager, Chief Financial Officer positions. City Council has approved budget amendments to address deficits under the consent agreement. There's monthly reporting that's going on now to the state regarding the city's financial condition. It's noteworthy to note that in February 2013, the FAB approved a revenue consensus process addressing 2013 and 2014 revenues. The second component is the milestones agreement, and the milestones agreement involved the approval of legal, financial, restructuring, pension, and healthcare advisor contracts. City Council approved those contracts in December 2012 and January 2013. That enabled the city to receive up to $30 million from the escrow fund. The third component of the plan is the joint mayor-city council cash plan. This plan was developed over the December 2012 recess period, and the plan on page 3 indicates that, yes, there was a projected cash shortfall of $114 million by June 30, 2013. However, the cash plan identifies $33 million to come from structural changes, which includes furloughs and pension days and revenue initiatives, $64 million to come from short-term cash opportunities, including pension and benefit payment deferrals, the $30 million from the escrow account. When you add the beginning balance of $30 million and back out the $36 million that would be distributed to taxing jurisdictions, you go from $114 million deficit to a $6.5 million surplus as of June 30, 2013. Going forward into 2014, with the full implementation and savings from the payroll and medical changes obtained from the imposition of the city employment terms labor contracts that were imposed back in July 2012, with additional headcount reductions and revenue initiatives, the city could end up with a positive $3.5 million cash balance as of June 30, 2014. Add to that full implementation of furlough days, incremental changes to active retiree health care and pension benefits, additional headcount reductions based on departmental reviews, looking at debt refinancing at lower interest rates, could generate up to an additional $150 million that would leave enough resources to address any one-time deferrals that would come due in 2014 and allow for monies to be used to start paying down the deficit in 2014. When you add to that the $52 million that's in the escrow account, much of those resources could be used to address the city's material weaknesses in financial systems and processes that were cited in the Financial Review Team report. It is understandable that the existing satisfactory plan has not proceeded as quickly as one would like. However, there are some reasons as to the slow implementation. The successful voter initiative to overturn PA4, lawsuits and legal challenges that were involved to block the implementation of the consent agreement, the lack of resources at the leadership, management, and staffing levels, challenges regarding employee morale, obsolete and ineffective information technology systems, and of course, through the normal process, the need for City Council to conduct its due diligence in reviewing contracts and proposals to address the city's financial crisis. Arguably, it would take up to a full 2 years for such an ambitious plan to be implemented. However, after only 8 to 10 months, the state, through its financial review team process, is taking the city down a different path, which could possibly lead to an appointment of emergency financial manager, which we are against. There are a couple items of the financial review team that I would like to point out. In regards to the accumulated deficit, yes, when you back out the debt that was issued to address the deficit, it shows a huge accumulated deficit. The financial review team says it's $937 million through June 30 of 2012. We contend that it's only $772 million, $165 million less, based on our review information of the CAFR and with our financial advisor, R.W. Baird and Company. In regards to deficit spending, cannot refute the issue of deficit spending that went on in the past. But there are three things now in place to ensure that the city of Detroit stops deficit spending in the future. That's the new Detroit City Charter, that's the consent agreement, and that's budget initiatives that have come forth from the Chief Financial Officer that has greater monitoring built in to avoid deficit spending. I would like to provide a different perspective on long-term liabilities. The financial review team has indicated that the city of Detroit has $15 billion in long-term liabilities, which exaggerates the city's future long-term obligations picture. A more accurate picture is that about half of that relates to the business-type funds, which includes water and sewage department. Those liabilities are supported by revenue streams, which are supported by rates or fees. There is no impact on the general fund. The remaining 50% of the long-term liabilities, about $7 billion, relates to the general fund. However, when you back out the $1.5 billion in pension obligation certificates, back out the pension UAAL, and back out the other post-employment benefits, you're just talking about $1 billion of general obligation bonds that are outstanding, and even half of that is supported by a debt service millage, which is a revenue stream. It is important to note that the city of Detroit is not anticipating a default on its general obligation bonds. And it's also important to note that there's only a debt service requirement associated with the general fund and including the debt service on the pension obligation payments of only $150 million. In regards to the $1.5 billion pension obligation, that was a good thing that the city did in order to lower the interest costs associated with the UAALs regarding the general and police and fire pension systems. In regards to the approximately $6 billion in the OPEB liability, with recent changes to the healthcare plan design and cost-sharing changes, as well as recommendations that will come forth eventually from the Milliman contractor, there should be methods to reduce this OPEB liability moving forward. So in other words, the city's long-term liability picture is not as bleak as depicted by the financial review team. Here's our recommendations. According to Moody's, one of the nation's leading bond rating agencies, an emergency manager appointment could trigger a termination event associated with series of interest rate swaps made by the city in 2006 and force a potential payment of $400 million, money, obviously, that the city of Detroit does not have. In addition, the appointment of an emergency manager could jeopardize the water and sewage bond ratings, which are currently A ratings. So the Detroit City Council firmly believes a satisfactory plan is in place to address the city of Detroit's financial emergency, and that an appointment of an emergency financial manager is not the best course of action at this time. The Detroit City Council would prefer that the current consent agreement be grandfathered under the new EM law, that's PA 436, which becomes effective March 28, 2013. Using relentless positive collaboration, the Detroit City Council recommends that the state of Michigan, the Bing administration, Detroit City Council, with the help of consultants and legal advisors and financial advisors, craft a modified consent agreement that includes detailed milestones with deadline dates to implement the joint cash plan and to address the city's deficit. This modified agreement would have a life of 12 months to enable the city of Detroit to implement the necessary changes to improve the financial condition. A number of actionable items could be included in the modified agreement that would take place upon its approval. restored powers to the program manager under the new EM law would enable him to impose on labor contracts that will expire and on existing city employment term labor contracts if necessary. And lastly, targeted investments to address the material weaknesses in the city's financial system, reporting system, could be addressed by using resources in the remaining escrow fund account. I want to thank you for this time and your attention.
Could I ask you just a couple of questions?
Sure.
In your statement, and particularly on page 4 of your document, you indicate that the plan has not proceeded as quickly as you would have liked, and that you can identify a number of items here which you say prevented the implementation of the plan. So, I guess I look at those and I say that some of those things may have impinged upon some of the initiatives, but many of the initiatives really could have been started even in the absence of having this, even in the face of PA4 overturn, and even in the face of lawsuits, there could have been some fundamental changes. So, I look at that and I say it would appear there that is there something different that's going on today with respect to those items you listed, absent the lawsuits and absent PA4?
Right now, on a monthly basis, the administration, starting back in September, has been a laundry list of the initiatives from the consent agreement. And there's a monitoring on the progress. There have been even subcommittees established within the Financial Advisory Board to work with the administration on these plans. These type of things take time. It takes time to vet them. It takes time to work with the appropriate individual. It takes time. So I would say the CETs that were imposed in July, that started the process of implementation. But when you see in September, you start seeing things lining out, based on the initiatives. And again, the Financial Advisory Board has been monitoring those initiatives along the way.
May I speak over?
Absolutely.
I'm Dave Whitaker, City
Oh,
Council.
excuse me, are we out of time?
I stopped it after they were done.
We were
Okay.
not out.
Okay, I'm sorry, go ahead, I just want
I did want to point out that many of the problems that relate to implementation that are listed on page 4 or 7 of Mr. Qualley's report, the city is beyond those points now, and I think that needs to be emphasized. This is all looking backwards at what happened with the implementation of the consent agreement. Those challenges, the legal challenges, the city has gone through those now. I'm afraid, to be honest with you, that a new initiative bringing in an emergency manager will guarantee more delay, not less delay.
I understand your position, Mr. Whitaker.
I think you're beyond having had the consent agreement in place now for a little less than a year. And of course, I did want to say a couple of words, if I may.
Well, your 20 minutes is over, so you may want to do that on
We did
your
have time, but
We had about 3 minutes left.
Did you, do you know how much time was left on the clock?
It's not going to take me long
All
to
right,
say
well,
what I
just a
have to
moment,
say.
why don't we just start the clock at 6 minutes and, out of courtesy to you?
Sure.
And why
Thank
don't
you.
we leave the clock continue? Go ahead, Mr.
I'm
Whitaker.
sorry.
That's all right.
I just wanted to point out that Mr. Qualley has spoken at length now and given you a document that shows that there is a plan in place. It is the consent agreement, the milestones agreement, and the cash plan that he went through for you. And we claim that that is a plan, a satisfactory plan that will get us through the initial period. But we have to understand that the financial stability agreement was a contract signed by the governor, the treasurer, and the mayor of the city of Detroit. is binding. It is a binding enforceable plan. That has been emphasized to the city from its inception. That once you sign this document, you're in it for the long haul. This document is scheduled to last for 3 years beyond the point where the city reaches fiscal stability. And of course, we're a long ways from that. The document also requires that the program management director and the chief financial officer serve a 5-year term. They're less than 1 year in. So it was contemplated from the very beginning that this would take a long time for the city to reach fiscal stability. That was the contemplation of the parties from the beginning. That currently is the situation now. So it is no surprise that when the state suddenly aborts after 8 months this plan and does a review team analysis, that it basically has a review team analysis that mirrors the first review team analysis that was done only less than a year earlier. Because it was not enough time for the city to reach the necessary changes, the fundamental changes that the plan required, given the short length of time that we had to operate. So it is our contention, quite frankly, that the current plan should be followed, just like it was contemplated from the beginning, and that patience be given to work this plan through. The governor has said on more than one occasion that it's Detroit City, Detroit, Michigan, not Detroit versus Michigan, that he wants to be a partner to the city. We certainly need to have the state as a partner, no question about it. We need resources that the city doesn't have, that the state presently does have. So to the degree we can partner with one another in this process and work our way to fiscal stability, that would be a benefit not only to the city of Detroit, not only to Southeast Michigan, but to the state as well, and I would say the entire region. It's important that the city comes back. Everyone knows the importance of the city, and it's important that we come back fiscally, no question. We're on board, we're with you in every way. The consent agreement, if given sufficient patience, takes us there. So it is our contention that patience be given and that we work as partners, not aborting a plan that we knew would last years after 8 months, and expect miraculous change in 8 months. That is insufficient in our estimation. We would say that the current plan that's in place should be allowed to see its way through, and that patience be given in that regard. Thank you.
Thank you, Mr. Whitaker. All right, with that, we'll proceed to rebuttal, and we will proceed to 10 minutes as soon as we reset the clock. And Mr. Hedden, would you like to speak?
Thank you, Ms. McDowell. A couple of items. Mr. Keelan, Mr. Whitaker mentioned the stability agreement and the review under PA 72. Of course, PA 72 was revived on August 8th of last year when PA 4 was suspended and subsequently disapproved. Under PA 72, if various conditions in Section 12 of the Act occur, the Department of Treasury is required to conduct a preliminary review. We have no discretion to do so. And certain conditions occurred in the city of Detroit, which triggered a review in December. Secondly, with regards to the stability agreement, that agreement rested upon a number of statutes, including PA 4, which no longer exists. So there are portions of the stability agreement that may still be active, but others not so. But certainly nothing in the stability agreement would preclude the Department of Treasury from conducting a new review under PA 72, which we were required to do. Secondly, Mr. Keelan mentioned a number of activities that occurred by the city in December, early January, wage cuts, furlough days, the 70-30 health care sharing, the hiring by the city of a number of consultants, most, if not all, of those activities occurred after the second review team was appointed. Indeed, in our meeting on December 20th with city officials, we expressed dissatisfaction with the fact that there appeared to be a lack of urgency on the part of city officials for dealing with a cash crisis. So I would submit that those activities referred to, most if not all of them, would not have occurred if the review team had not been hanging over the heads of city officials like a sword of Damocles. With regards to Mr. Corley's comments, there are three I would like to respond to. One is the countermeasures and the fact that there may indeed be a $6 million surplus this year as opposed to the cash deficit. We're aware of that, and we were aware of that at the time the review team was sitting. That's an estimate that yet remains to be seen. Although, as Mr. Corley pointed out, approximately 2/3 of the countermeasures or short-term measures are not structural. Only about 1/3 are long-term structural measures. Some of them involve timing issues, such as not paying bills or making certain deferrals that would occur after June 30th of 2013. So while we recognize the existence of them, we simply didn't think that they were sufficient or adequate to constitute a satisfactory plan. Two other items. One is the possibility, as Mr. Corley pointed out, that the appointment of an emergency financial manager might trigger a so-called termination event. The city has a number of swap agreements out, and under the terms of those swaps, counterparties may be involved in a triggering event under certain conditions. The appointment of an emergency financial manager is not the only event that might trigger a termination event. There are others, at least one of which has already occurred. And in that instance, I believe city officials, possibly state officials, are negotiating with counterparties to avoid a termination. So it's not simply the possibility that an emergency financial manager might cause that. Other events of equal consideration could also cause the same outcome and are being worked through. There's no reason why the parties couldn't negotiate if an emergency financial manager were appointed to avoid a termination event. And then finally, with regards to the long-term liabilities, which the review team did peg at $14.9 billion, we did not suggest that some of those long-term liabilities don't have revenue streams attached to them, such as Mr. Corley pointed out, water and sewer, for example. But they're still long-term liabilities of the city, as are the OPEB liabilities. My long-term liabilities would be a lot less if I were to back out my mortgage, but I would still owe it. And so all the long-term liabilities listed in our report are in fact long-term liabilities of the city. They may be in different funds. We did not suggest they're all in the general fund of the city. Some of them may have revenue streams behind them that are dedicated either through millages or from other sources. But as a bottom line, they are in fact long-term liabilities owed by the city of Detroit. And they are in fact $14.9 billion. That is the only point that we were making. And so I don't believe sort of picking various ones of those out on the basis that they perhaps have a dedicated revenue stream attached to them in any way changes the overall point that we were making, which is that the city has a staggering amount of long-term debt, whatever the category, that the residents of Detroit are going to have to pay back over the long term.
Does that conclude your remarks, Mr.
Yes,
Wright?
it does.
Thank you. Okay, let me shut that off. Reset, please. No, would you like to make some comments?
I would.
All right.
Generally, I recognize this is not a court of law or a court of appeals, but I think we all recognize that the legal framework for this hearing and the legal framework for what happens next is going to be challenged. There's been a couple of references to prior legal challenges to the first piece of this FSA, the Public Act 4, and ultimately the vote in November. It is predictable that, in fact, what happened in that Public Act 4 instance was the first challenge was filed by the General Retirement Fund and the Police and Fire Retirement Fund. And thereafter, there was a steady drumbeat of litigation initiated by other shareholders who had something to lose, unions being primarily involved. I would predict that if this action leads to the appointment of an emergency manager, this will be another wave of similarly placed lawsuits. No one can control that, and there's no reason why that process has to be laid at the door of the city of Detroit as an indication of lack of cooperation. I would reiterate what Mr. Whitaker said earlier. This FSA was entered into by all parties intending for it to last for a period of time. That period of time has not even been, it has not elapsed. There's still time to go on the appointment of the program management director and CFO. I would suggest that introducing at this stage the new element of an emergency manager is an invitation to drop back to April of 2012 and relitigate the questions that arose under Public Act 4.
Thank you, Ms. McDowell. In regards to the countermeasures, it is true that 2/3 of the cash plan represent short-term measures. However, when we were looking at developing this cash plan, we put on the hat of an EM. What would the EM do? The EM would look at low-hanging fruit items, asset sales. That's not unusual that an EM would look at. Outsourcing, looking at deferring pension payments to give you that time, that window to address labor contracts, and with the understanding that in the next fiscal year, we're going to have full year savings from the labor changes that were done back in July, coming in 2014 to address those short-term items. So I don't think that's unusual. In regards to the interest rate swaps, yes, it is true that the downgrade that the city suffered back in November was a potential triggering event. Why add another layer to that? If there's an appointment emergency manager, why add a layer to that? And lastly, in regards to the long-term liability, $15 billion is a large number. What we're just saying is that for years, the city has issued debt for the Water and Sewage Department to do capital improvements, to address the Clean Air Act in regards to the combined sewage overflow projects. Those are huge projects, but that we were mandated to do. And yet, there's sufficient revenue streams come in to pay those bonds. So the point we were just making is that, yes, there's a lot of debt out there, but much of it is supported by continual revenue streams that have been on the books for years.
I just got one last comment, if I may. Our position, just to wrap it up, is stay the course, continue the current consent agreement. I guess in my neighborhood, when I grew up, we were taught a deal's a deal. I think in your neighborhood, you probably heard the same thing. We have a deal on the table. It is not over. And we say keep the current deal that you have in place. There is no place in Act 72 or 436 that allows for both a consent agreement and a emergency financial manager or emergency manager. It's one or the other. And I contend you already have a consent agreement. That's in place. It will grandfather in under 436, as Mr. Corley has indicated. The law is clear in that regard, and I say stay the course. If there is more milestones that are needed in order to make sure that certain triggering events occur in a timely manner, certainly that could be incorporated. Any document, in my estimation, is never perfect. Even the great documents that we gave you to read today, we probably could have spent a few more hours on those documents. But the truth is, everything can be improved, and to the degree that the financial stability is on the table, it may be a few things that could be improved in the document. But to say that the city council or the city is not cooperating, I'm afraid that I have to disagree. Even yesterday, the contractors that the city employed to give advice on restructuring presented to the Financial Advisory Board. So the contract is working. The contract is working. You're getting the information that you contracted for that will help the city restructure itself, to help the city fall within the parameters of our revenue. Hopefully we can get that revenue up and we can bring more services back to the people. But certainly the plan that's in place gets us where we want to be without creating the displacement of elected officials, which in my estimation is beyond anti-democratic. Why take a move like that that's so provocative when you have a document in place that everybody signed on to? Why is it necessary? And I contend it isn't. So I say stay the course, a deal's a deal. Thank you.
Thank you, Mr. Whitaker. Any other comment from you? All right, with that, I'm going to conclude this hearing. I am going to take the information presented today and the information that you provided me last night, and we will review that information, and I will make a determination and provide that report to the governor. Thank you for attending today.
Thank you.